Good afternoon, this is Sean Golding with Golding & Golding, here to discuss the basics of the Flora Rule and how it impacts FBAR litigation in federal court. So by way of brief background, the FBAR Foreign Bank and Financial Account Reporting, FinCEN Form 114, is not a tax form. In fact, it has nothing to do with U.S. tax, other than the fact that starting in 2003, the Internal Revenue Service took over enforcement of the form. The form has been around since like 1970. It's a creature of FinCEN, Financial Crimes and Enforcement Network, and it is filed on a form, FinCEN Form 114. The problem with the FBAR is that it's really unfair to U.S. taxpayers because taxpayers don't really have an opportunity to dispute the penalty at the IRS level beyond an appeal. Why? Because you can't go to tax court for the FBAR. You know, the IRS holds all the cards on this one. On the one hand, they get to aggressively enforce foreign account penalties, which can be astronomical, and especially when it's non-willful, has nothing to do with the value of the account, other than that's used to determine the cap on penalties. But you can get hit with several $10,000 penalties depending on the value of the account, even if there is no unreported income associated with it. Okay? Especially with the recent updates to the delinquency procedures. So, in a recent case at the U.S. Court of Federal Claims, Mr. Mendu had a significant amount of FBAR penalties, and he wanted to bring a claim against the U.S. government. Normally, the rule was you would have to wait until you're sued so that you can dispute it, or you have to pay it in full, and then you can sue for refund. That's the Flora Rule, right? Flora Rule says you can't sue the U.S. government for a tax violation situation unless you first pay the full amount and then you sue for refund. Okay. In this particular case, Mr. Mendu sued the U.S. government regarding the FBAR penalties and said, I shouldn't have to pay the full amount up front because it's not a tax. Of course, the government disputed it and said it's still being handled in the realm of tax law, right? Kind of weaselly, and he should be required to make full payment up front under the Flora Rule. And in this particular case, the court sided with the taxpayer and basically said, look, on the one hand, you can't say that someone can't sue in tax court because it's not a tax, but on the other hand, they're required to make full payment in advance as if it was a tax. You can't have your cake and eat it too. So in this particular situation, it's not at the Court of Appeals yet or anything like that, but this recent decision is great for taxpayers because it would give a taxpayer the opportunity to sue in federal court even without having to make the payment first. And if you know anything about FBAR penalties, those penalties can be astronomical. A lot of people don't have $500,000 just sitting around to pay just for the luxury of being able to try to fight the penalty to litigate it in federal court. If you're out of compliance and you want to get into compliance before any of this kind of stuff happens, before you get dinged with any penalties, there's various amnesty programs available to help you. We have lots of free information available on our main website and our sub-websites. It's goldinglawyers.com. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.